The promulgation of the new constitution on the 27th of August the year 2010 set in motion the setting up of the Supreme Court as the most superior court in the country. The 7-member court is established under Article 163 of the Constitution. Section 3 of this article provides that, among other things, the Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to the elections of President. It is also seized with appellate jurisdiction to hear and determine appeals from the Court of Appeal and any other court or tribunal as prescribed by national legislation. But be that as it may, it is the decision of the Dr. Willy Mutunga-led Supreme Court to quash over 5 electoral petitions that has left legal pundits scratching their heads over the sanctity of such decisions. Only last Friday, the Supreme Court reinstated Okoth Obado as Migori County Governor, quashing the nullification of his election by the Appellate Court on grounds of electoral malpractices.
Declaration of the result of the election by the Independent Electoral and Boundaries Commission in respect of the seat of Governor of Migori County is hereby restored.
The previous day, the same court upheld the election of Silva Sanami as Shinyalu Member of Parliament. Also reinstated by the Supreme Court were Meru County Governor Peter Munya, his Garissa County counterpart Nathif Jama, and Nyando Member of Parliament Fred Outa. Othaya Member of Parliament Meru Amboi has also been a beneficiary of Supreme Court decisions.
As you have heard the verdict from the Supreme Court today, it is re-emphasizing the fact that the law has already been settled in the Munya case, and the court wants to send the message that rulings coming from the Supreme Court are consistent, and I think it's an advice to the Court of Appeal that it should comply with Article 163, Article 4 of the Constitution, that obligates the Court of Appeal to follow the judgments of the Supreme Court.
In most cases, Supreme Court judges have cited one key reason for the dismissal of the petitions, namely wrong interpretation of the law by appellate judges. The only rare cases where the Supreme Court has upheld Court of Appeal decision is in Mathare, where a by-election is set for August 7th. Of key concern to legal pundits is what may have informed the decision by the Supreme Court to dismiss most of these petitions. Is it possible the Supreme Court fears that failure to order fresh elections will technically validate the court coalition's argument that the last election was flawed? Was the benchmark set by the Supreme Court during the last landmark election petition so low that it's bearing the brunt of it all? Does the nullification of this election petition cast aspersions in some way to the competence of appellate judges? And if the Supreme Court verdicts are anything to go by, does it mean many plaintiffs in the past had to bear the consequences of erroneous rulings by the Appellate Court prior to the coming into force of the Supreme Court?
Our sweet and victory was going to be taken away from us through crooked means. Na Mungu amesema pana.
Mwanje for Channel 1 News Hour.